Federal judge just threw out 10 of Blake Lively's 13 claims against Justin Baldoni, including every single sexual harassment count. The internet immediately split into two camps. Team Blake says it's just legal technicalities. Team Baldoni said she got destroyed. Both camps are a bit wrong. The sexual harassment claims failed because of where the movie was filmed and how she was classified in her contract, not because the judge decided that nothing happened. And the three claims that survived are going to trial in 6 weeks. And one of them is specifically about whether Baldoni's team ran a coordinated digital campaign against her. That's the claim that a jury is about to hear. Welcome back to Exhibit A-List, where pop culture gets cross-examined. I'm your host, Jasmine Weg. I'm a lawyer, and I break down the contracts, power dynamics, and legal realities behind the stories everyone's talking about. A quick reminder, the Instagram is Jasmine Weg ESQ, and the podcast Instagram is Exhibit A-List Pod. And you can find me on TikTok, Jazz the Lawyer. You can follow, rate, review, share this podcast with anyone who needs a legal bestie. Now, before I just jump into a rundown about the stories and then get right into it, I just want to say I'm so grateful and happy to be here. Right now, my family and I are renting an Airbnb, so we're away from home. That's the different location, the different background. We're enjoying our time in a sunny location, spending the holidays with family. Of course, I could have skipped a week, and I'm sure no one would be mad. This podcast is still new, but I just actually love doing this. I truly do. I love getting to put together the weekly stories and getting it all together and then actually making it happen, recording it, putting it out there, hearing it live, having people engage with it, hearing your thoughts, talking about things that everyone's talking about, and engaging with the conversation with all of you. It truly makes me so happy. I'm so privileged to get to do something I love to do. About a year ago, I was talking to people and saying, I want to start a podcast. And when I said it, it just sounded so impossible. And it's so cool that right now I am here. This is episode 27, loving every minute of it. I haven't missed a week yet. I'm so blessed. I'm just grateful, and I really truly hope that you enjoy listening because I do this with so much love, and I'm just excited to keep doing it. So with that, we have a full docket today. Blake Lively ruling. You know I was going to talk about it. We'll talk about what it actually means and what's still going to trial. Now, Poo Shiesty and Big 30, those are some rappers. They're getting federally charged for allegedly kidnapping Gucci Mane at gunpoint to get out of a record contract. Insane story. I need to walk you through why that plan failed on every possible level. So let's get into it. Blake Lively versus Justin Baldoni, the ruling. This ruling dropped April 2nd, and I've been watching everyone post their hot takes without actually reading the 152-page opinion. And listen, I didn't read the entire opinion either, but there's stuff we're all missing. So let's slow down and talk about what actually happened. Of 13 claims were dismissed. That's the headline. But the reason why they were dismissed is doing a lot of work that a lot of people aren't talking about or just glossing over. Quick background if you needed. You might have been living under a rock till now. Blake Lively sued Justin Baldoni in December 2024. He alleged a number of things, which included sexual harassment on the set of It Ends With Us. And she also alleged that Baldoni and his team, specifically the crisis PR people, Melissa Nathan and Jennifer Abel, launched a coordinated smear campaign against her after she complained about the on-set behavior. Baldoni then countersued for $400 million. He made a number of claims against her. Most of his claims were dismissed as well. So we have been waiting on Justin Baldoni's summary judgment motion decision for months because he made this motion a while ago. Judge Lyman has said that the sexual harassment claims failed on two independent legal grounds. First, Lively was an independent contractor, not an employee. So the federal law that prohibits sex discrimination in employment only covers employees, which means you have to have an actual employment contract, and it can't be that you're an independent contractor. So this isn't a finding that nothing happened, but it's a threshold legal determination about who gets to sue under a particular law. Second, her statute, which is actually stronger than federal law, those fail because the conduct actually occurred in New Jersey. So there's a territorial requirement that there has to be some nexus between where it happened and the state law. Filming happened in New Jersey, so California law does not apply there. Lively's own attorney actually made a statement saying that the court's ruling that the harassment claims couldn't go to trial was about legal technicalities, not an endorsement of the defendant's conduct. So, what is going to trial? The retaliation against the production entities, meaning Wayfarer Studio, breach of contract for the rider agreement, and an aiding and abetting retaliation claim against the agency PR crew. The most important thing that happened is Baldoni himself, as the individual, was dropped from all remaining claims. So the case is continuing to trial against the companies. He is completely out of the lawsuit. There are no claims that survived against him individually. That's huge. That is a huge win for Justin Baldoni. Baldoni's team is saying that they are very pleased that the sexual harassment claims were dismissed and calling them very serious allegations. That's technically accurate. Legally, he did win. Lively's team, though, says that the retaliation is the heart of the case. So our team is actually saying that the most important claim is still alive and well, and that it always was the heart of her case. So it does remain. The retaliation claims survive. The smear campaign story is what's going to trial, and that's a very interesting story. Here's my read. Lively's case got narrower. Her core allegation has to remain that retaliation claim. It's going to be a very interesting case because it's really going to be a toss-up on how the jury will view things. The jury is going to hear in May whether Wayfarer orchestrated a digital smear campaign against her for speaking up about on-set conditions. What's interesting is that the judge wrote that he wasn't deciding whose account was more credible. He said that Lively provided more than a scintilla of evidence, which means like a crumb of evidence, and that is like the baseline that Wayfarer took adverse employment action against her because of her protected activities, i.e., reporting the sexual harassment claims. Language means that a reasonable jury could rule in her favor. Doesn't mean they will, but there's a possibility. It's still open. But yes, she did lose on a lot of her claims. Justin has gotten himself out individually, and that is a huge win. The trial starts May 18th. Both sides are expected to testify, and it's going to be super interesting to see how the live trial coverage will be. I want you guys to let me know if you guys want me to go down because it's going to be in my hometown. Should I go and try and get into court and listen in on the trial? You guys have to comment on this podcast episode and let me know your thoughts. Also, until now, even as recently as this past week, settlement talks have failed. The judge has been encouraging them to try to settle. It isn't working, folks. This is going to a jury. Now we're going to talk about a wild story. Poo Shiesty, Big 30, and the gunpoint contract. I've been a lawyer for years. I've seen a lot of contract disputes, and I have never seen one go quite like this. Prosecutors are now saying that Poo Shiesty lured Gucci Mane to a Dallas recording studio under the guise of a business meeting, pulled out an AK-style pistol, and forced him to sign a contract release. Point. 9 people have been charged. Poo Shiesty, the real name, Lontrell Williams Jr., is the alleged ringleader. Also charged, his father, Lontrell Williams Sr., rapper Big 30, and 6 others. They're all facing federal kidnapping charges, which carry a potential life sentence. Here's how it allegedly went down. January 10th, 2026. 3 music industry professionals, including Gucci Mane, who owns 1017 Records, fly to Dallas to what they think is a meeting to discuss the terms of Pooh's recording contract. Once they're inside the studio, Pooh takes Gucci into a private recording room. His dad and Big 30 are also in the room. He pulls out AK-style pistol, forces Gucci to sign the contract release, then takes his wedding ring, watch, earrings, and cash. Meanwhile, outside in the control room, the other defendants are robbing the other 2 victims at gunpoint. One person was choked to near unconsciousness. Then, this is the part, several defendants immediately got on social media posting the stolen jewelry. We gotta talk about the evidence here for a second because it's almost comically thorough. Who was on home confinement for prior federal firearms conviction in Florida. He was wearing an ankle monitor. The ankle monitor data placed him at the studio. His phone records corroborated travel from Memphis to Dallas. His dad rented the car they drove. It's like they created the paper trail. Surveillance footage exists from the studio, a nearby hotel where they stayed, and I'm not making this up. The Staples, where prosecutors believe that someone printed the contract documents hours before the robbery. There's footage from that too. And then the social media posts of the stolen goods. All of it on the record. If you're going to commit federal kidnapping to get out of a record deal, maybe don't post the Rolexes on Instagram 1 hour later. We gotta be mindful about it. Now let's talk about the actual legal situation here. This is layered. Who had previously served time for a gun charge. He was released from federal prison in October 2025. He has been on home detention since then, which means that conditions included no firearms, restricted movement, and he allegedly committed armed kidnapping while on home confinement, while wearing an ankle monitor, and then posted evidence on social media. From a criminal law standpoint, federal kidnapping carries up to life. If convicted, the fact that he was already on supervised release when this allegedly happened will make his sentencing situation significantly worse. His father is also charged, which raises a whole separate set of dynamics. On the civil side, which I know no one is talking about right now, you cannot enforce a contract signed under duress. If Gucci Mane had a pen put in his hand at gunpoint, that document is void. Duress is a complete defense to contract enforcement. So whatever he thought he was accomplishing legally, the answer is nothing. You cannot force someone to sign a contract at gunpoint and then show up in civil court and expect it to hold. That is not a contract, it's a crime. 8 of the 9 defendants were arrested within a day of the charges being announced. The 9th was picked up in Atlanta shortly after. As of this recording, the case is pending in the Northern District of Texas. We're definitely going to follow this story because it's wild. Absolutely wild. Now, Tiger Woods, here's what we know. On March 27th, Tiger Woods was driving his Land Rover on Jupiter Island, north of Miami, when he clipped a pickup truck pulling a trailer. His SUV flipped onto its side. He was able to crawl out. No one was seriously injured, and then he was arrested on suspicion of DUI. The sheriff's office released body cam footage on April 2nd, and this tape does a few things simultaneously. It's kind of humanizing and kind of damning, depending on what detail you're looking at. On the humanizing side, jokes with the deputies about the Masters. They asked if he was going to play. He said, hoping so, depends on y'all. He asked them to rescue his golf clubs from the vehicle, and mentioned that he'd won 14 majors with that putter. Deputies were pretty clearly starstruck. Less so than the police that we saw who pulled over Justin Timberlake and we couldn't even recognize him, and he couldn't seem to get across the fact that he was on a world tour. One of Tiger's arresting officers said they broke the back windshield to retrieve the clubs and told the tow employee there was expensive stuff from a high-profile person that needed to come out. At one point, he's outside the scene on his phone saying, I was just talking to the president. It's unclear if that's literally Trump, whose former daughter-in-law Vanessa is reportedly dating Woods. Trump was asked about the incident later and said he felt so badly for him. Now here's the less humanizing part, the field sobriety test. He told deputies he had looked down at his phone and went to change the radio station. The breathalyzer, however, showed no alcohol. He refused the urine test, which is itself a charge. Deputies found pills in his pockets. He told them he'd taken a few medications with the specifics largely redacted. He's been charged with DUI with property damage and refusal to submit to a lawful urine test. He pleaded not guilty. His attorney filed to allow him to travel outside the U.S. for inpatient treatment, which a judge did grant. He's stepped away from golf indefinitely. Masters officials confirmed he would not participate this year. To me, this sounds like he's about to do an apology tour. He's going to go to rehab and then come back and talk about his struggle. From a legal standpoint, though, refusing a urine test in Florida triggers an automatic license suspension and is treated as an aggravating factor. Under Florida's implied consent law, when you get a driver's license, you're considered to have consented to chemical testing if you're suspected of DUI, driving under the influence. Refusing is its own offense in Florida. His attorney is going to have to decide whether the DUI charge can be defended on the merits or whether a plea makes more sense. And that calculation depends heavily on what the toxicology ultimately shows if any testing was ever completed. At the end of the day, the video does seem humanizing in a way that cuts both ways. Juries do see humanity in defendants, but him saying I was on my phone is not a DUI defense. And it's an admission of least distracted driving. But this one's still early. The legal proceedings are just starting. The body cam tape is out there, and it's already part of the record in the court of public opinion where we all make our decisions early. Now we gotta talk Afroman because footage from his trial has been all over the internet. His story happened a couple weeks ago, and I've been waiting for the right place to put it because it genuinely made me happy. Afroman, real name Joseph Foreman, Grammy nominated. You know him from Because I Got Hot. Won a jury verdict on March 18th against 7 Ohio sheriff's deputies who had sued him for almost $4 million. The jury deliberated for less than a day and found in his favor every single claim. Now, here's the background. In August 2022, Adams County, Ohio sheriff's deputies executed a search warrant on Afroman's home. The warrant was based on probable cause related to drug trafficking and kidnapping. They went in with guns blazing, kicked his doors down, rifled through his closet, his CD collection, his cash. One deputy, this is the part, to stare at a lemon pound cake on the kitchen counter. Folks, you just cannot make this stuff up. They found a joint, a vape pen, and over $5,000 in cash. The cash was returned. No charges were ever filed. The raid was later acknowledged to have failed to produce any probative criminal evidence, which means any evidence suggesting of real criminal behavior. Afroman had home security footage of all of it. And instead of just suing, which he considered and decided against, he made an album about it. Lemon Pound Cake, released in 2022. You know we love a salty, savage revenge album. Songs on there were titled The Police Raid, Why You Disconnecting My Video Camera, Will You Help Me Repair My Door? I love it. He put the footage in the music videos. He sold merch with stills from the raid. He posted it everywhere. Here's a quote from him. As a powerless black man in America, what can I do to the cops that kick my door in? The only thing I could come up with was make a funny rap song about them. The 7 deputies sued him in 2023 for what everybody that gets mentioned on my podcast almost always sues for: defamation, as well as invasion of privacy and unauthorized use of their likenesses. They claimed they'd been ridiculed and received death threats. One deputy said that he'd received hundreds of pound cakes at work. Bro, that does not sound that bad. Come on, share it with the office. They sought $3.9 million total. Sometimes when I hear these stories, I want to meet the lawyers that are bringing these claims because, it's embarrassado. The thing is that the lawyers' names, while they're public, in all the filings, they don't get shame or shade for bringing these cases. I guess that's good for our field, but sometimes you need a little shame. The trial lasted 2.5 days. Afroman showed up in a head-to-toe American flag suit with a white fur coat. He took the stand. He argued that everything he said was based on real footage from a real raid that produced zero charges. His attorney argued that exaggerated, hyperbolic, satirical content directed at public officials is constitutionally protected speech and cited everything from NWA's F the Police, remember that song, to Cardi B to establish that rap as a genre is recognized social commentary and not literal factual assertion. I'm not sure if he cited this, but he should have mentioned that when Drake tried to sue Kendrick Lamar for defamation when he called him a certified P and Not Like Us, Drake lost because the court said that it was hyperbolic and rap is protected speech in that sense. The deputy's lawyer told the jury that a verdict for Afroman would mean that artists could say what they want no matter how untrue. The defense said, yes, actually, that's kind of the point when you're satirizing public officials. I want to hear your thoughts. Please drop me some comments. What side are you on here? Let me give you the legal framework, though. To win a defamation claim, the plaintiff has to show a false statement of fact. Satire and parody are not statements of fact. They're commentary. When the plaintiff is a public official, the bar is even higher. To prove actual malice, meaning that the defendant knew the statement was false or acted with public disregard for its truth. I'm going to pose a question to you all to sit and think with. Do you want to live in a world where when you make jokes or when our comedians or our singers or artists create satire, they can be subject to lawsuits which will create a censorship out of fear of civil backlash, out of fear of having to pay fines? Do we want to create a situation like in this case, when it's a public figure, the defendant had to have known that the statement was false or acted with reckless disregard for its truth. The officers who execute search warrants are acting in their public capacity, so they're considered public officials. They're subject to criticism. The First Amendment protects the public's ability to criticize them. ACLU, the American Civil Liberties Union, filed a brief calling this a textbook SLAPP suit, SLAPP, strategic lawsuit against public participation. Those are lawsuits that are filed not to win on the merits, but to silence critics through the cost and the burden of litigation. Because remember, folks, everyone has to pay their own way. You pay to defend yourself in a lawsuit, and very rarely in America do you get your legal fees reimbursed unless you have a contract with the person who sued you that said whoever wins in this lawsuit will get legal fees. And there are some other exceptions. The jury here apparently agreed with the ACLU. The judge said, in all circumstances, the jury finds in favor of the defendant. Afroman outside the courthouse said, I didn't win, America won. And look, I want to acknowledge the complexity here. Some deputies said that their kids were harassed at school. That's real harm. That's terrible. I don't condone or encourage that. But the remedy for not liking how someone reacted to a failed raid on their home is not a $4 million defamation lawsuit. And it's probably more of a statement of society nowadays that when we hear about things in social media, like, for example, people who heard Afroman's story, the fact that they took to harassment of the police officers' families is disturbing. The comfort with which people feel to enacting their own renegade law is scary as well. Everyone in this world could benefit from a lesson in boundaries, but that's not the topic of today's podcast. The deputies, though, they brought this case to court, and by doing so, they made Afroman famous again and made the pound cake officer internationally recognizable. And now Taylor Swift is getting herself back to court again. This time she's being sued over Showgirl trademark. Taylor Swift's 12th studio album, The Life of a Showgirl, dropped in October 2025. She sold 4 million copies in its first week, 12 weeks at #1. It's been a big era, and now she's getting sued over the name. A Las Vegas performer named Marin Wade, her real name is Marin Flagg, filed a suit on March 30th in federal court in California. She's claiming trademark infringement, designation of origin, and unfair competition against Swift and UMG recordings. So here's the basis of her claim. Since 2014, Wade has been writing a column in Las Vegas Weekly called Confessions of a Showgirl, a behind the scenes look at life as a Vegas performer. Now, that column became a podcast. That podcast became a live show. The trademark Confessions of a Showgirl in 2015. It eventually achieved incontestable status, which for trademark purposes means that it's been in continuous use long enough that the right to use it is essentially locked in. You can't challenge an incontestable mark on certain grounds. And here's the part where Swift's team arguably walked into this one. When they applied to trademark Life of a Showgirl, the U.S. Patent Office refused the application because it was confusingly similar to Wade's existing trademark. They were on actual notice, but they went ahead and used it anyway. Wade's argument is that the two names share the same structure, blank of a showgirl, the same dominant phrase, showgirl, and the same commercial impression in the entertainment space. He argues that Swift's massive commercial presence has functionally swallowed her brand, with consumers now assuming that her decade-old Confessions of a Showgirl is somehow derivative of Swift's album. So there's an interesting wrinkle here that I think is worth flagging. Wade had posted enthusiastically about the Swift album before filing suit. He posed in a showgirl costume to Shake It Off, Swift's song, and she used the album hashtag. She alluded to the album release date, and then she went silent on social media in October 2025. Her attorney's explanation is that the confusion was causing harm and eroding her brand, but her prior posts are going to be exhibit material for Swift's team. You can have a valid trademark claim and still have been publicly hyped about the thing that allegedly infringed on you. Those aren't necessarily inconsistent. It is going to be a big moment in discovery, and she's going to have to defend that well. So let me break down what Wade actually needs to prove. For trademark infringement, she needs to show that she owned the mark, that Swift is using a very similar mark in commerce, and that the use is likely to cause consumer confusion. The fact that the Patent Office rejected Swift's application for the trademark is going to be very significant here, because it's third-party confirmation that it was confusing to begin with. But the harder question here is consumer confusion. Wade is a Las Vegas showgirl with a podcast and a local show. Taylor Swift is a global phenomenon pop star with a 4 million unit album. Is there any confusion whatsoever? The names might be similar, but consumer overlap? Would there actually be a perceived connection? That's a fact intensive inquiry. I don't really think there is perceived confusion, but it's going to require evidence, surveys, expert testimony. These type of cases can cost hundreds of thousands of dollars to litigate through to a verdict. Another thing worth noting, Wade's claim is actually targeting the merch and the branding and not the underlying music. Her complaint specifically says that she respects Swift's right to creative expression and is not challenging the album itself. She wants an injunction, which means stopping of the use of showgirl merchandise and branding. The album can stay. Swift's team has not responded yet. Thing is, Swift doesn't need this fight. Wade has a real legal argument. The calculus for resolving it quietly versus litigating through is pretty clear to me. What do you guys think? Now, any court is in session where the stakes are low and the feelings are high, and I am your judge and jury. Today's case involves a specific category of person who saw the TSA chaos headlines, decided the solution was to arrive at the airport at 4 a.m. for a 9 a.m. flight, and in doing so, created the exact problem they were trying to avoid. The charge, vigilante airport math, only works on paper and actively punishes everyone around you. Here's what actually happened. TSA operations were disrupted and lines got crazy long. We were all hearing about it in the news. People missed flights. It was bad. But then TSA came back online, and everyone was so afraid that people started coming crazy early for their flights. And suddenly, you have someone online for a 5 p.m. flight with someone online for a 10 a.m. flight. And the lines are around the corner. I may or may not have just been standing in those lines a few days ago, and I'm personally injured by these people. Because legitimately, I was on a line that went outside JFK, came back in, went outside one more time, and then looped back in, and that was the TSA pre-check. You know, the faster line. Airlines have actually come out and said on social media, do not arrive more than 90 minutes early for a domestic flight. That's a direct instruction from the people who run the airport. They're done telling you what your dad told you about arriving 2 hours early. We're all killing it for everyone else. We all ruined it. Anyone who showed up 4 hours early, stood on a line that did not need to be that long, and made it long, you are the line. You became the inconvenience that you were so afraid of. The defense will argue, I was just being cautious. I have anxiety. I cannot miss this flight. And while I do hear you, is not caution. That's chaos with good intentions. And the law, specifically the unwritten law of shared public spaces, does not accept good intentions as a defense. Well, my verdict is that you are guilty with a mandatory sentence of arriving exactly 90 minutes in the airport, not 91. You will sit with a coffee and an overpriced airport sandwich, and you will trust the process. Court is adjourned. Please proceed to your gate in an orderly fashion. Well, that's it. Was episode 27 of Exhibit A List. I am Jasmine Weg. If you've been here from the beginning, thank you genuinely. If you're new, stick around. We do this every week. My absolute pleasure to convene with you every week and talk about all the legal buzz that's happening. If there's anything that is picking your brain that you want me to talk about, please let me know. Leave a review, share this with whoever needs a lawyer bestie in their life, and I will see you next Monday. Court is adjourned. Stay curious, friends. Bye.